You sit here, and if I make reference to bastardizing the court, and I didn't say that the Chikwesin had done so, but you sitting here, you have done exactly that. You say what? Victim of injustice by the courts of this country. How so? Why was it a kangaroo process?
Is that not an opinion?
How is it an opinion?
No, if I go to court,
decision doesn't make sense. It's an opinion.
No, I'm saying if I go to court.
No, Randy, I'm coming. Please, I'm asking.
Yes.
That the gentleman you say is a victim of injustice by the court of this country. It's an opinion. It's your opinion. And that the decision of the court doesn't make sense. It's an opinion.
Right. You see, Bobo is just performing wonders here. The things he's saying on this platform, I'm not sure that he believes the things he's saying.
Why do you
and I'm not sure you will. No, because you know that what he's saying is totally baseless.
How so?
Number one, on your claim that I've bastardized the court. He says I've bastardized the court because I say that the courts have done injustice to Judge Chikwesi. That is bastardization of the court. Is that what we were taught in the law school? Master, when we are haven't you drafted a notice of appeal before? The standard formats for drafting notice of appeal. What are some of the grounds? That the decision of the courts below constitutes a gross miscarriage of justice. What is the meaning of that? What is the meaning of miscarriage of justice? You've not heard. Oh, hold on. Let's go one by one. Let's go one after the other. What is the meaning of travesty of justice? Hold on. What is the meaning of travesty of justice?
If you think that
don't you hear lawyers
words like that?
Chief, you've had your time.
Let's hear.
Chief, you've had your time. You see, I'm not one of those that you can blackmail and incite me against cause against me.
I'm not inciting
because I know what I'm saying.
I'm only saying
what is the meaning.
I don't think that words like senseless.
Am I here to talk about it?
Okay.
Am I here to talk about
let's go on.
You think?
Go on.
Let's start from your point about injustice. I'm saying that what is the meaning of travesty of justice? When lawyers stand on their feet in court of appeals, challenging decisions of court below, and they describe decisions of the courts or rulings of the courts as travesty of justice, does that amount to bastardization of the court? How can it's mere statement that the decision by the court in that send-off matter has done injustice to Kwesi amount to bastardization of the court? Look at the desperation you are displaying. Then now he says that I said that the decision of the court is senseless. Stop. You people, you can lie. On this very platform, you are lying. Have I used the word senseless?
That decision.
I said the decision of the. Hold on. Is that the same as senseless?
What
you don't understand what I'm saying? If you are quoting me. You don't want us
Okay, but let's hear Sammy.
You are a long-standing member of this show. You know the rules. Let me have my time.
Yes.
These are very serious matters. Look, I have not said any decision is senseless. Those are your words. Yes. You know that, so don't lie. I said the decision of the courts in that send-off matter doesn't make sense in the light of the rules and the facts. What is wrong with that? Haven't you seen lawyers and judges describing court decisions as absurd? You've not heard the word absurd before. Do you know the meaning of absurd?
Okay,
do you know the meaning of absurd? Haven't you heard judges and lawyers describe decisions as unreasonable? What's the meaning of unreasonable? Don't you hear it in court every day? Haven't you been a practitioner for many years? So as for you, because of politics, you've thrown all the law you've studied away, and now you're only engaged in mischief. You know these things, so please don't do that. Don't do that. Because what you're doing is dangerous. You are sitting here creating an impression that Gyamfi says the court is senseless. When I've never said that. But you know what I said. And you know that what I've said is very in line with legal balance, and I've said nothing wrong. So stop the blackmail and let's discuss the substantive issues.
Whenever I say my PENDREAM TV there, I see them yopo
jurisdictions has jurisdiction to grant reliefs relating to a parliamentary election without a hearing conducted via petition to question the election in the High Court. End of quote. Despite what her leadership said has been settled through cases, we now have a decision of the Supreme Court that, contrary to what has been settled, claims to invalidate a parliamentary election. Let me quote another passage from the ruling of Justice Tokono in that same ruling in the Amewu case. Quote, by providing that the validity of elections is questioned only through a process that allows for a trial, the situation of deciding the validity of an election on the strength of a motion and affidavit evidence has been disallowed by statute and judicial interpretations on Articles 33 and 99 cited above. Justice Doche said in the Baba Jamal case that, quote, once the Constitution and statutory law, namely Section 16(1) and 2 of PNDC Law 284, have both provided a remedy and a forum for the adjudication of certain types of disputes, to wit, the validity of the election of a member of parliament, it follows that it is that forum and procedure that must be strictly applied, end of quote. He had earlier in that judgment stated, quote, I am therefore of the firm opinion that once the law has provided that the only valid method in PNDC Law 284 by which election disputes are to be commenced is by petition as distinct from writs of summons, then it follows that if that prescribed method or procedure is not strictly followed, what has been wrongly commenced cannot be accomplished. Once the first interested parties have failed to strictly adhere to the provisions of PNDC Law 284, as will be shortly established, it follows that the actions falls flat in the face of the law. This must not be countenanced by a court of law, especially the Supreme Court for that matter. This is because it is from the Supreme Court that all other courts take direction and guidance, because of the principle of stare decisis. The application of the principle of stare decisis or judicial precedent does not involve an exercise of judicial discretion at all. It is what must be done. That is done. It is, in essence, mandatory. End of quote. And it goes on and on. It says similar statements from the Supreme Court can be quoted from other cases. It goes on the G.H. Mercer and Willency constituency cases. And it says, I'm waiting to read the full judgment of the Supreme Court whenever it is made available. But there's no doubt that the decision as announced on 17th May 2023 flies in the face of many previously decided cases. We wait to see whether the words of the various justices which I have quoted will be respected by the panel. Having made that point, let me make it clear to everyone that the most important thing to me right now is to contest and win the by-election, which is the result of what the Supreme Court announced on 17th May 2023. I am determined to continue serving the good people of Asin North with all my heart, soul, body, and all the resources I can muster for the benefit of my constituents. I've been deeply touched by the amazing support and encouragement from you in the constituency after the Supreme Court decision on 17th May 2023. I was particularly moved by your show of love and support through the vigil organized by the youth at Asim Breku on Sunday 28 May 2023. The massive attendance showed the depth of the support and encouragement I'm receiving. I was really touched. Even before the Supreme Court decision, you, my constituents, have been sending me your messages of support and encouragement, and I'm deeply grateful. I've also received support and encouragement from many in this constituency and beyond, including some outside Ghana, who are not necessarily NDC members, but who continue to demonstrate the outreach at the injustice I'm being subjected to in my bid to serve my people. I'm grateful for all the support. I remain eternally grateful to the leadership of the NDC for the solid support I've enjoyed from day one. And it says that he also makes a few observations about the issues in court and all that. This is quite lengthy, so I'm not going to go through all of that. And he goes on to say that I know that you, the people of Asin North, are ready for the by-election. Since last year, April, when the Supreme Court stopped me from performing my duties as your representative in Parliament, you have been without representation in the 8th Parliament of the 4th Republic. Like the people of South traditional areas who are excluded from representation in this Parliament, you, the people of Asin North, too have been in that unacceptable situation for over a year. The by-election, which must be held within 30 days of the decision of the Supreme Court, will bring an end to this situation. The will of the people of Asin North must triumph. Democracy must be restored. I urge you all to come out in your numbers to vote for me, so I return to Parliament and continue the work I began to do on your behalf towards advancing the Asin North development agenda. God bless Asin North constituency and the people. God bless Ghana. James Jechikwesin, Asin North constituency, 1st June 2023. Now, Global Info Analytics, a Ghanaian polling agency, has tipped the NDC to win the Asin North constituency seat in the upcoming by-election. The head of polls for Global Info Analytics, Musa Dankwa, told the media a recent poll conducted in April showed that the NDC will win the seat based on factors such as road network in the constituency, the standard of living of constituents, and general optimism. Quote, if you look at the recent polling that we did at Asin North as recent as April, there were signs of hope for the NDC to retain the seat, in a sense that the sentiments of voters in the constituency doesn't seem to support the ruling party. If you look at voters who said the country was headed in the wrong direction, they were about 77%. Now, people who said that the standard of living had gotten worse in the last 12 months were about 66%. And when you look at people who said they were not optimistic things will get better in the next 12 months, they were about 80%. Oh, I see not.
Well, not surprising.
With respect to the expectation that Honorable Gyamfi was going to put himself up, albeit the fact that as we speak, there is a criminal prosecution that is ongoing, which, when concluded and is found guilty, potentially would result in his incarceration. Because there's precedent to it. I recall Andrew Sakandi, my very good friend, who subsequently departed this earth, was faced with the same circumstances where even though he had commenced the process of renouncing the citizenship of UK, it had not been concluded at the time that he filed to contest the Boku Central seat, I believe in 2009. Subsequently, the court found him guilty and he was duly incarcerated in accordance with law. But of course, the choice really is his, whether he would want the good people of Asin North to go through the process of having to elect an MP for the 8th Parliament on 3 occasions in the event that he is convicted. Because I would have thought that he will sit it out, conclude the criminal prosecution, so that if he is found not to have committed any offense, then he can avail himself to contest again subsequently at the next election. Because the consequences of an action such as this is known to all of us. As far as I'm concerned, the law is settled. But obviously, he has a different view. And he is entitled to his view. It's not for me to, as it were, proffer any advice to him. Save that, I would have wished that we all save ourselves the expense and the brouhaha that is associated with by-elections, so that we can have one once and for all, so whoever is elected can represent the people of Asin North in peace until the next general elections in December 2024. But obviously, his own call, respect to the statement that he's issued and the contents thereof, I'm sure he articulated all these before the court, and the court found that indeed he was unfit to have contested at the time that he did. So to attempt to relitigate it in press statements to court public affection, I discount it entirely. The fact of the matter is that he went through due process. He was found to have flouted the law. His election has been duly declared as unconstitutional, null and void and of no effect. If he has any recourse, it is to a review. But then again, the decision itself has not been released. Court indicated that it was going to file it on or before the 8th. 8th is next week. And so let's await the filing of the decision by the court, and then we can interrogate it, because I'm sure that whatever it is that the Supreme Court justices have to say will definitely be made public. But my worry really is if we are dissatisfied with decisions of the court, our penchant for going out to, if you like, bastardize the court. That, Randy, I think, as the last bastion of our democracy, which seeks to protect the sanctity of our democracy, we should, as political actors, as much as possible, work to stay away from that. Because it doesn't help anybody. It doesn't help the growth of our country. I say this in respect of the decision from yesterday on the Domelevo one,
yes,
where people are hailing the court because the decision that the court delivered seemed to go against government, and the decision that government took, irrespective of the fact that the letter that Nana Santibide to uttered was clear precedent in 2009 when the then Secretary to the President, Mr. Babaku Mensah, signed the same thing. I mean, if you read the text of both letters, it's practically word for word. Okay, but of course, at the time, nobody challenged it. This time, it's been challenged, and people are hailing the decision of the court, which was unanimous. But recall some other decisions that this same Supreme Court has delivered, and the kinds of things that were said about the court. Unanimous FC. Very recently, some member of the NDC was actually cited by the Supreme Court, invited, and of course, in the run-up to his appearance before the court, he put out some statement to try and extricate himself from the statements that he had made, which, for all intents and purposes, is not worth repeating on this set. But words like that, I don't think that it helps the conversation at all. We can agree to disagree, and Sammy, better than I know, that when you put an issue before a court, okay, especially when it's a multi-panel, or it's a panel, not an individual, the chances of you getting two people giving different reasons for whatever conclusions that they arrive at is real. You may disagree, but the extent to which we go to bastardize the courts when they deliver judgments that are not satisfactory to us or doesn't serve our purpose, I think we should desist from that kind of attitude. But that said, I wish Gyamfi well. I'm certain that with the kind of things that the NPP has done, of course, when we're going into Kumehu, even though there was a strong hold of the NPP, our friends on the other side sought to suggest that they were going to make some inroads in that constituency. The people of Ghana, of course, the people of Kumehu demonstrated to all of us that, hey, we know what we see. We know the difficulty that we are in. We know the context within which that difficulty that we are facing as a people has arisen. And we trust the NPP to be the one that can salvage us from the situation that we find ourselves in. And so we'll vote for an NPP candidate to continue in the performance of his functions in Parliament. I would expect that the good people of Asin North would evaluate the issues devoid of the propaganda, devoid of the politicking, if you like, and return an NPP candidate to represent them in Parliament and not risk the potential of another by-election, which, as far as I'm concerned, is very real.
Sammy?
Doc, first of all, a very good morning to our cherished viewers. I'm super excited that Honorable Gyamfi has officially declared his intentions to contest the Asin North by-elections on the ticket of the National Democratic Congress. And as National Communications Officer of the NDC, I have the full permission and authorization of the party to announce that the entire National Democratic Congress, its leadership, the rank and file, are solidly united behind the candidature of Honorable Gyamfi Kwesi. We are united behind him because Honorable Gyamfi Kwesi, first of all, is the choice of the people of Asenoff. There is no doubt about that. He is a people's choice. And he is our surest bet of winning this by-election, which is the creation of the New Patriotic Party. If you look at the results from the 2020 parliamentary elections, it is very clear that this is a man who is loved by his people. The votes Honorable Kwesi pulled, which is in excess of 17,000 votes, specifically 17,498, was far more than the votes that the presidential candidate of the NPP, Nana Addo Dankwa Akufo-Addo, got, which is 16,065 votes, and the votes the presidential candidate of the NDC got, which is 15,014 votes. So this is a parliamentary candidate, a member of parliament, who is really loved by his people to the extent that he got more votes than all the presidential candidates in the elections in the Asenoff constituency in 2020. This is a constituency that we had lost in 2016 by close to 57% to the NPP. And so that showing, that impressive showing of Honorable Kwesi tells us that across the divide, because clearly if you look at the vote difference between him and former President Mahama, it is very clear that there are NPP people who voted for him, and there are many neutrals who may not have voted for the NDC but voted for Honorable Kwesi. And so who rather do we present in this by-election than this man who was elected barely 2 years ago by the people of Asenoff to represent them in parliament because they believe in his love for the constituency, his vision for the constituency, and the plans he has for the constituency. Again, Doc, I'm excited that Honorable Kwesi has officially declared his intention to contest this by-election because he is a victim of injustice, and that injustice must be corrected. And the people who have the power to correct the injustice that has been perpetrated against Honorable Kwesi by the cause of this country are the good people, the electorate of Asenoff. And I have no doubt in my mind that they will tell the cause of this country that they have done injustice to their member of parliament and right that wrong. You see, my friend Agyapa Mercer said people are bastardizing the courts. Look, all the things you read on this matter, what did you read which amounts to bastardization of the court? You read Honorable Kwesi's declaration of intent. What has the Honorable former member of parliament said in that statement that bastardizes the court? This attempt,
a general statement, not necessarily.
Then that general statement had no basis in the context of the discussion, because he is basically expressing.
You cannot set what I see.
No, but I have a right to express an opinion on what you say.
So I'm
and
just
my opinion on what you said.
The comments that I made. Anyway, you go ahead.
My opinion on what you said is that it has no legs to stand on in the context of this discussion. Honorable Kwesi has not bastardized the court. He's simply engaging in a constructive, commonsensical, legal criticism of a court decision. And we are allowed to do so. In fact, we are taught to do so as law students and as lawyers. Master, it should be obvious to every objective mind that the decision by the Supreme Court in the case of Honorable Gyamfi Kwesi is a travesty of justice. It's a gross miscarriage of justice. It's a decision that doesn't make sense based on established precedents by the Supreme Court and based on the facts of the case. And I'm very surprised that Honorable Agyapa Mercer, who is a lawyer, will seek to equate this case to the Sakande case, when the two cases are materially distinguishable. Doc, Adamu Sakande was sitting in parliament with 3 passports. And while in parliament as a member of parliament for Boko Central, traveled at different occasions on 3 different passports. He traveled at some point on his Burkinabe passport. He traveled at some point on his British passport, and on other occasions on his Ghanaian passports. And in each of these 3 traveling documents, he had different places of birth. In his Burkinabe traveling document, his place of birth was Burkina Faso. In his Ghanaian passport, his place of birth was Boko. So this was a clear case of forgery. This was somebody who was sitting in parliament making laws for the people of this country whilst holding 3 passports and whilst using those 3 passports for traveling purposes. The same cannot be said about Honorable Gyamfi Kwesi. What are the facts in this case could have anticipated COVID? Nobody. This was a pandemic that affected all the nations of the world and led to the closure of many government institutions. So the process which he started in December 2019, which was supposed to be completed by June 2020, delayed by no fault of his. But it is very clear that before he came to Ghana to serve his people, before he came to Ghana to contest the NDC parliamentary primaries in 2020, he had already applied to renounce his Canadian citizenship. And the 6 months period had already elapsed. Now, because of COVID, the process delayed. And so at the time he was picking nominations to contest as MP, picking nominations from the Electoral Commission of Ghana, the certificate of renunciation had not been issued to him. That is a fact. But Doc, at the time he was presenting his nomination forms, he had the certificate of renunciation. As at the time he was being voted upon on 7 December, he had the certificate of renunciation. As at the time he was being sworn in on 7 January 2021, he had the certificate of renunciation. So he never sat in our parliament to make laws as a member of parliament with 2 citizenships. I don't even want to bring in the issue of allegiance because it is a totally different matter. And it is very sad how our cause have sought to equate citizenship to allegiance. And I don't want to go into that whole academic debate of the difference between allegiance and citizenship. But my point is that, assuming without admitting that allegiance is the same as citizenship, this is a man who, as far back as December 2019, had severed his allegiance to Canada by putting in an application for renunciation of citizenship. And as at the time of him submitting his nomination forms to the EC, had received this certificate of renunciation. As at the time of his election, had received his certificate of renunciation. As at the time of being sworn in to become a member of parliament, had received his certificate of renunciation. So in terms of the spirit of the law, talking about Article 94, which proscribes members of parliament, or which says that a person is not qualified to contest as a member of parliament if he holds dual allegiance. He had not breached that spirit of the law, because he didn't enter parliament with dual allegiance or dual citizenship or dual nationality. This is very, very, for me, it is open and shut. And yet, you have the High Court in Cape Coast saying that even though Honorable Kwesi applied to renounce his Canadian citizenship as far back as December 2019, and even though he was issued a certificate of renunciation as a completion of that renunciation process, by the time he submitted his nomination form, by the time he was elected, he is still not qualified. He was still not qualified to contest. You know why, Randy? Because according to them, at the time he picked the nomination forms, he didn't have the certificate of renunciation. What cock and bull story is this? It's been violated. This is a clear case of injustice and political harassment against an innocent man who, despite the comfort he was enjoying in Canada, chose to come down to serve his people who were facing all manner of hardships as a result of years of neglect by successive governments. What crime has Honorable Kwesi committed? So don't make the mistake of equating Gyamfi's matter to Sakande, the two issues are materially distinguishable. And as a lawyer, you should know that. Again, see, I am very surprised, Doc, about the date that has been said by the Electoral Commission. Well, I'm not surprised. I don't even know why I said I'm surprised. I'm not surprised because this Electoral Commission will do everything to give the NPP more time to buy votes and engage in all forms of monetization in a sense. That is what's wrong with because for me, this by-election should have taken place not later than 7th of June.
Why?
Based on Section 3 of the amendments of Article 112 of the 1992 Constitution. And if I can read that to you, Article 112 of the Constitution as amended now by Section 3 of the Constitution of the Republic of Ghana Amendment Act 1996. This is what it says. Whenever a vacancy occurs in Parliament, the Clerk of Parliament shall notify the Electoral Commission in writing within 7 days after becoming aware that the vacancy has occurred. So he writes to the Electoral Commission, informing the Electoral Commission that a vacancy has occurred within 7 days of becoming aware. So the vacancy occurs first, and upon becoming aware, the clerk is supposed to write to the Electoral Commission within 7 days of becoming aware. So his letter to the EC is not what creates the vacancy. His letter to the EC only communicates or notifies the EC of the vacancy that has already occurred. So I take it again. Whenever a vacancy occurs in Parliament, the Clerk of Parliament shall notify the Electoral Commission in writing within 7 days after becoming aware that the vacancy has occurred. And a by-election shall be held within 30 days after the vacancy occurred. So the by-election is supposed to be held not 30 days after the EC is notified, but 30 days after the vacancy occurred. Look, you understand? This is very clear. 30 days after the vacancy occurred. That is what the law says. Yes. This vacancy occurred by virtue of a Supreme Court decision on the 17th of May. The letter from the Clerk of Parliament dated 28th of 29th of May is not what created the vacancy. It's what notified the EC of the vacancy that had already occurred on the 17th of May. And that is why the letter from the clerk made reference to the Supreme Court decision as of 17th of May. And so if you are supposed to conduct the by-election within 30 days of the occurrence of the vacancy, 30 days from 17th of May, does it fall on 27th of June? They are not prepared. They don't even have a candidate. The NPP, they are the ones I'm talking about. So they are now jumping all over the place trying to conduct a primary. I already conducted primary, select a candidate. And they are busy mobilizing contractors, okay, to go into the constituency, send equipment to the roads in the area, which they have neglected all these years, and create an impression that all of a sudden, because of a by-election, they care about the people of Asenof. The same shameless conduct they engage in at Kumawu. That is what they want to do. And engage in the same monetization. Maybe in the case of Asenof, it may even be bigger. The same practice of vote buying that they engage in Kumawu. And that is why the EC is pushing the election further. Because this election, some of us have been pushing for this by-election as far back as last year. The earlier we go for this election, the better. We have no doubt in our mind that the people of Asenof are discerning. They will not neglect, they will not reject Honorable Kwesi, who has only proven to love and to be interested in their welfare and then their development. In the short period that Honorable Kwesi became or served as a member of parliament for Asenof, Asenof was restored back to the path of development and progress. Things that the people of Asenof had never seen, they began to see. That a member of parliament in opposition could engage electrical engineers to service 40 street lights procuring and distributing, installing over 1,500 street lights, 1,500 within a short space of time. There are members of parliament who are in their fourth term who have not even been able to do that. You go into their constituencies and it is total darkness. But under Honorable Kwesin, who was member of parliament for less than, before he was sent to court, he had not even served for 6 months. And he had not served for 2 years when his election was invalidated by the Cape Coast High Court. But he had done all these things: the rehabilitation of schools, the reshaping of roads that he has done, the provision of potable water. So we know that the people of Asenoff will not only vote for justice, but they will vote for true development. And they will read in between the lines and appreciate the shenanigans of the NPP and their vote buying gimmicks, and know that it is only temporal. It is only a ruse to deceive them into voting for them, and that they will be neglected immediately they get their mandate. Asenoff is a swing ridge, a constituency. The NPP has won it more than the NDC has done so. If they had any good intentions for the people of Asenoff, they will not wait for a by-election before they will engage the services of contractors to go and do their roads for them. They have some of the poorest roads you can find in Ghana, in Asenoff. So we know that the chiefs and people of Asenoff will vote for development and they will vote for justice. Justice must prevail in this matter, and we are ready. We don't want to engage. I've heard what the NPP Communications Director Richard Agyapa has said. Talk is cheap. Now they say talk is air. The job is on the ground. We are not going to talk plenty. All rules now lead to Asenoff. And if you are an NDC member, or you are a Ghanaian, or you are from Asenoff and you are listening to me, know that this by-election is a by-election like none other. Because this by-election is a referendum on the performance of the Kufuor Bawumia government. And the people of Asenoff have a responsibility to send a clear signal to this government that they have been a monumental failure, and that they are ready, the people of this country are ready to hold them responsible for the unprecedented hardships, the bankruptcy that they plunged this country into because of their recklessness and their mismanagement. That is all I have to say. Doc, I'm tempted to respond to what he said on the Dumelovo matter, but I don't know whether you will table it. Okay, because that equalization you sought to do is totally baseless. We'll come to that.
Randy, I was giggling when Sammy Gyamfi. It seems to me that he's been in Harvard since 2000. When did we even start constitutional democracy? 1992, yes. He's been in Harvard since, and that this is his first by-election that he's witnessing in this country, because otherwise I don't see what the issue is with the development projects that is going on there. I don't think it's the best thing to do, in all honesty. But you have a situation where the pot of resources that you have as a nation is not sufficient to fix all our problems at the same time. And so if there's a by-election that comes up, everybody's attention is then focused on that constituency to try and do something to influence, if you like, or make the people vote for the governing party. And consistently since 1992, every by-election that has taken place, that is what takes place. And so, please, come back to Accra. Leave the Ivy League down.
You're justifying that.
No, I'm not justifying. I admitted right from the very beginning that I don't think that that's necessarily the best. But he made some points that I think needs some response. You see, the deception must stop. Randy, this statement that the EC has issued, in the 4th paragraph, it says interested candidates are required to download nomination forms from the Commission's website from 1st of June 2023. That's picking the form. What has this got to do with anything? I can download it now. That doesn't mean I'm going to contest in Asenoff.
What's the point you're making?
So the point is that picking the form is immaterial and can never be the basis for anybody to be disqualified or qualified.
Of course, it is only when you submit that your intention to contest would have been manifest. Now, anybody can pick a form. Why? People pick forms all the time and not submit. So to sit here and say that at the time that the gentleman picked the forms, he did not have the renunciation certificate, it's completely material. Obviously, what would be material then would be at the time that he filed. If he indeed had the renunciation certificate at the time that he was filing his nomination, because election day and also the day of the swearing in is immaterial. Just as the day that you pick the form is immaterial. It is only when you file. That is when you make the declaration, you depose to the oath that on this day, I, Andrew Kofi Agyapa and Mercer, filing to contest the parliamentary seat for Sekeni constituency, is a Ghanaian and owe allegiance to no other country. It is only that declaration that you can be held accountable to. So what is he talking about? If he had that, why didn't he exhibit it to his documents to prove that on the day of the filing, the date on the renunciation certificate indeed confirmed that he owed allegiance to no other country? We've seen the certificates around. When was it issued? So don't deceive the people. Be truthful. It helps. You sit here, and if I make reference to bastardizing the court, and I didn't say that the Chikwesin had done so, but you sitting here, you have done exactly that. You say what? Victim of injustice by the courts of this country. How so? Why was it a kangaroo process?
Is that not an opinion?
How is it an opinion?
No, if I go to court,
decision doesn't make sense. It's an opinion.
No, I'm saying if I go to court.
No, Randy, I'm coming. Please, I'm asking.
Yes.
That the gentleman you say is a victim of injustice by the court of this country is an opinion. It's your opinion. And that the decision of the court doesn't make sense is an opinion. Really? That's an interesting opinion to proffer. But I'll leave it to the judgment of our listeners. You see, look, we can disagree with the decision.
Yes.
I don't have a problem. You can criticize the decision.
Yes.
But if you use words like the decision doesn't make sense, what are you saying to convey?
Because you are a lawyer.
It's unbelievable.
You are both lawyers. I'm a non-lawyer. Let me ask you something as a non-lawyer. When we listen to decisions by the courts, judges, there's something you call, I'm trying to get a name. There's something which has nothing to do with it's like a commentary, but there's a term for it. When the judges are reading their
obiter.
Yes.
Yeah.
Yes. Now, anytime I listen to obiter by judges, I mean, they can be very, very choicy in their words and expressions. Anytime
or sometime?
I'm saying that anytime I listen.
You listen?
Yes, I'm not saying anytime they deliver. Yeah, I'm not saying anytime they deliver. I'm saying anytime I listen. I can hear that when it goes to the obiter, they can be very, very choosy and have some very choicey. I'm trying to choose my words carefully in saying, and the liberty is unfettered.
Randy?
Yes.
Granted. But if you think that it is by so doing, and I don't think that the judges use words like senseless and stuff like that. If you think that somebody describing the decision of the court,
no, I'm not saying that. The point I'm just making,
to point to people saying that a lawyer should know that.
No, Agyapa, the point I'm just making is that I can take some judgments and I can look at the obiter and I can mention, I can quote particular things that judges have said. The point I'm just making is that how come that judges can decide in their obiter to say whatever they want to say? And I'm asking this as a layman. They can say whatever they want to say, however they want to say, use whichever words they want to use.
Such as create loot and share.
whichever they want to.
But if
the
facts fit that description, why?
No, you won't let me finish what I want to. No, I'm not finished.
Any specific, any specifics.
So just allow me to finish. Okay. If they say all these things about you, you have no remedy. You can be disappointed. You can have issues with it, but that's it.
No, you have a remedy.
Which is?
Your remedy is to go for a review.
No, you are going for a review on the basis of Obita. You can't.
No, but of course, I mean, it's a decision.
No, I'm just saying that Obita has nothing to do with the facts of the matter. I'm saying that judges can run commentary. I just want to see. I'm seeking knowledge. You go to the court.
Oh, Randy, this
I'm
knowledge
saying, no,
is not within you.
No, I'm just saying because I'm just asking.
Yes.
That how come they are at liberty to in their Obita say anything that they want to say? Yet, on the other side, for those who are the recipients of their decisions, are not at liberty.
Andy,
that's just what I want to understand.
Nobody has said that people who are recipients of decisions of the court are not at liberty to criticize the decision.
No, that's not what I mean. You know that's not what I mean.
Yeah, but of course, I mean, I this conjecturing that you putting across that you want to invite me to make a comment on, I'm not prepared to take that invitation.
Okay.
But you see,
yes.
Another point.
Yes.
Look, the reports of Adamu Sakanda's conviction is available. I'm looking at a Ghana Web report that clearly states in there that in July 2012, an NPP member of Parliament for Boko Central, Adamu Dramani Sakande, was convicted by an Accra High Court after he was found guilty of perjury and forgery. This was after he failed to denounce his UK citizenship before contesting for the Boku seat. And if my recollection is right, that was the basis for the matter that was brought against him in court. But you see, Randy, why? People don't have multiple passports in this country, in other countries. In fact, some countries actually give you passports when you buy property. I see adverts on social media, Dominican Republic, where even Dubai are here. Really, what's the issue? So to say that the gentleman had 3 passports and was sitting in parliament making laws to make it look as if holding multiple passports in themselves is a crime, I don't think it's right.
But
okay, no, hold on. Yes. I'm coming. However, like I said, the point is that at the time that he contested, he still held his British passport, which showed his place of birth as Ghana. Okay? So, yes, he had to fall on the sword that, the law had offered for people who fall foul of that offense. And he suffered the consequences for it. I don't have any issues. But when the shoe is on the other foot, then people want to put out justification to make it look as if somebody is targeting an individual for purposes of depriving the people of Asin North of their member of parliament. But the truth of the matter is that at the day that this gentleman filed his nominations to contest for the parliamentary seat of Asin North, regardless, even if it's true, and it's not for me to tell, that on the day of election, he had received the renunciation certificate. That in itself does not validate his ability to contest. Because at the day that you make the declaration, that's when you are held accountable for the statements that you make. Okay, but we are awaiting the decision that the Supreme Court has to deliver on the 7th. And then we can come back and interrogate it if the need arises for us to do so. But I don't think that the court erred in anything that it did. and sitting here to bastardize a court, calling their judgments senseless, is really not helpful at all.
All right, Doc.
So just before you come in, the minority chief whip, Honorable Abuja, it says that during the vetting of the Chief Justice nominee, she answered a question I put to her. I asked if describing a judgment as unwise was an issue. She responded by saying describing a decision as wise or unwise was acceptable. Says tell Agyapa to calm down. And she says that the Supreme Court ruling and the interpretation by the Attorney General is absurd and lacks clarity. They therefore, in the case of Adamu Sekende, ask that his record should be expunged from the records of Parliament. What does expunge mean? Yes.
Doc.
Right.
You see, Bobo is just performing wonders here. The things he's saying on this platform, I'm not sure that he believes the things he's saying.
Why are you
And I'm not sure you will. No, because you know that what he's saying is totally baseless.
How so?
Number one, on your claim that I've bastardized the court. He says I've bastardized the court because I say that the courts have done injustice to Judge Kwesi. That is bastardization of the court. Is that what we were taught in the law school? Maza, when we are, haven't you drafted a notice of appeal before? The standard formats for drafting notice of appeal. What are some of the grounds? That the decision of the courts below constitutes a gross miscarriage of justice. What is the meaning of that? What is the meaning of miscarriage of justice? You've not heard. Oh, hold on. Let's go one by one. Let's go one after the other. What is the meaning of travesty of justice? Hold on. What is the meaning of travesty of justice?
You think that it's
Don't you hear lawyers
words like that?
Chief, you've had your time.
Let's hear.
Chief, you've had your time. You see, I'm not one of those that you can blackmail and incite me against cause against me.
I'm not inciting
because I know what I'm saying.
I'm only saying
what is the meaning.
I don't think that words like senseless.
Am I here to talk about what you think?
Okay.
At all.
Am I here to talk about
let's go on.
You think?
Go on.
Let's start from your point about injustice. I'm saying that what is the meaning of travesty of justice? When lawyers stand on their feet in court of appeals, challenging decisions of court below, and they describe decisions of the courts or rulings of the courts as travesty of justice. Does that amount to bastardization of the court? How can a mere statement that the decision by the court in that send-off matter has done injustice to Kwesi amount to bastardization of the court? Look at the desperation you are displaying. Then now he says that I said that the decision of the court is senseless. Stop. You people, you can lie. On this very platform, you are lying. Have I used the word senseless?
That decision.
I said the decision of the. Hold on. Is that the same as senseless?
What
Oh, you don't understand what if you are quoting me. You don't want us.
Look at this man.
Okay, but let's hear Sammy.
You are a long-standing member of this show. You know the rules. Let me have my time.
Yes.
These are very serious matters. Look, I have not said any decision is senseless. Those are your words. Yes. You know that, so don't lie. I said the decision of the courts in that send-off matter doesn't make sense in the light of the rules and the facts. What is wrong with that? Haven't you seen lawyers and judges describing court decisions as absurd? You've not heard the word absurd before. Do you know the meaning of absurd?
Okay.
Do you know the meaning of absurd? Haven't you heard? Don't encourage him to. Haven't you heard judges and lawyers describe decisions as unreasonable? What's the meaning of unreasonable? Don't you hear it in court every day? Haven't you been a practitioner for many years? So as for you, because of politics, you've thrown all the law you've studied away, and now you're only engaged in mischief. See, you know these things, so please don't do that. Don't do that. Because what you're doing is dangerous. You are sitting here creating an impression that Gyamfi says the court is senseless. When I've never said that, you know what I said. And you know that what I've said is very in line with legal balance, and I've said nothing wrong. So stop the blackmail and let's discuss the substantive issue. Then he says that Sakande, he tries again to compare the Sakande case to the Judge Kwesi matter. Look, had Sakande renounced or applied to renounce his British citizenship 1 year before he was elected as Member of Parliament, how do you equate that to Judge Kwesi? who applied to renounce his Canadian citizenship as far back as December 2019 and never used his Canadian citizenship for anything, never used his Canadian passport for anything. You, Sakande, you were sitting in parliament with 3 passports whilst being a dual national, not even triple nationality, because he says he's a Burkinabe by birth. On his Burkinabe travel document, his place of birth is Burkina Faso. And then he says that he's a citizen of Britain too, and he holds a British passport. And whilst sitting in parliament, you travel. Listen, by your conduct, the Jomoro MP has been acquitted, or you don't know, the case against the election petition against her has been dismissed. So while sitting in parliament, by your conduct, you travel on those passports. That's clearly upholding your allegiance or citizenship of those other countries. And if you don't know, the report you read only presented you with partial facts. Let me read to you another report from the same Ghana web, titled, dated 12 August 2009, titled MP Holds 3 Passports. And this story is a report on the evidence in chief of an immigration officer in charge of Kotoka International Airport, Nolasco Nyedu, who testified against Adamu Sakande. And the story reads, the witness who said this in his examination in chief, led by Miss Gertrude Akins, acting director of public prosecutions, in a court presided over by Justice Charles Quest, also quoted various passport numbers as well as the expiry days used by the accused person to travel. I'm talking about Sakande, as well as his date of birth on various certificates. In addition, the immigration officer also read information on the places of birth of the accused person, while the date of the birth of the embattled MP on the 3 purported passports remained the same. Mr. Nyedu also read out information on the documents which showed that while he was said to have been born in Boko on the Ghanaian and British passports, he was said to have been born in Burkina Faso on the Burkinabe passports. Everything is stated in there. So that was what that case was about. And I still maintain what I told you, that at the time, save the time Honorable Kwesi picked these nomination forms, he had his certificate of renunciation. At the time of submitting his forms, at the time of his election. Because even if you look at the representation of people's law, it talks about being qualified to contest at the time of your election. At the time of your election. Not at the time of picking nomination forms or submitting nomination forms. Because really, what did the framers of the 1992 Constitution intend to achieve by the provisions of Article 94 against dual allegiance? Did they seek to prevent a person from picking nomination forms or submitting nomination forms whilst holding dual allegiance? Certainly not. What they sought to prevent was having a person sit in parliament as a member of parliament for Ghana, making laws for us, while holding dual allegiance. And I'm saying that in the case of Kwesi, at the time of his election, at the time of him being sworn in, and at the time he served in parliament as a member of parliament, he never at any material time had dual nationality or dual allegiance. And that is why, for me, I say that this case is a travesty of justice, and that the case doesn't make sense in the light of the law and the facts. And finally, if you look at the arguments that Honorable Kwesi has advanced in his declaration of intent, he talks about precedents of the Supreme Court, about their own lack of jurisdiction in election petition matters. He cites the J.H. Mercer case. He cites the Baba Jama case. He reads to you what justices of the Supreme Court who presided on this case have said on similar matters previously, where disputes over parliamentary elections were brought to the Supreme Court, and the court was called upon to invalidate those elections. The Supreme Court indicated clearly that that was not the forum for invalidating any parliamentary election, and that when it comes to parliamentary election, the forum is the High Court. This matter first of all went to the High Court. The Cape Coast High Court gave a certain decision. It was appealed against, and that process was ongoing. And then a fresh writ was issued in the Supreme Court, seeking to declare the entire election of Gyamfi Kwesi as unconstitutional. And our position, which was articulated, canvassed, by lawyer Chachuchi Kata, who represented Gyamfi Kwesi, was that the Supreme Court lacked jurisdiction in the light of their own previous decisions, as has been quoted in the statement you read from Honorable Gyamfi Kwesi, where they have stated verbatim, including the most recent case of Hohoe involving Peter Miwu, which ended up in the Supreme Court. When these same judges said that, look, what you are seeking to invalidate is a parliamentary election, go back to the High Court. If you have a problem with what the High Court has done, go to the Court of Appeal. It is only constitutional matters that arise in the course of the High Court trial that are supposed to be referred to the Supreme Court. But to issue a fresh writ in the Supreme Court seeking to invalidate a parliamentary election, and the justices of the Supreme Court who have in previous decisions indicated that the Supreme Court have no such jurisdiction in this particular case, now seize the jurisdiction to actually invalidate the election, and even before they did so, injunct the member of parliament, leaves much to be desired, in our opinion. And we are right in criticizing that decision, and that does not in any way amount to the bastardization of the court. Look, let's move on. I'm done.
Manevra asema PENDREAM TV. PENDREAM TV de osia dem yopo